Very good evening to all of you. First of all, I would like to extend a warm welcome to all of you to this Public Interest Lawyers Colloquium on the theme Protecting Civil Liberties During Emergencies. Does COVID-19 pose new threats to rights and freedoms? As all of us know, 2020 has presented us with an unprecedented crisis of COVID-19. With over 3.7 million confirmed cases and over 250,000 deaths already, we are faced with one of the largest crises of our times. Governments across the world have already introduced emergency laws in response to COVID-19 pandemic. However, as humanity goes into a rare state of lockdown, the situation has been correctly described by some as a human crisis, which is fast becoming a human rights crisis, possibly a humanitarian crisis. While the casualties of the pandemic have questioned the access to very basic right to healthcare, the response to battle the pandemic has questioned the access to basic human rights and freedoms. The coronavirus threatens everyone. However, it is human rights which uplifts and empowers all of us as people. Therefore, it is important to strike that balance between the necessary restrictions of civil liberties while protecting them during emergencies. As this state of social distancing and quarantine begins to become more of a new norm, it is important to address an issue that concerns all of us. Does COVID-19 pose new threats to rights and freedoms? How do we protect and even strengthen our constitutional rights while we are to some extent being asked to temporarily suspend them in some cases? This colloquium is a unique platform to come together to understand how we can find our collective consciousness to identify means to protect our cherished rights and freedoms. We are very fortunate that we have a very distinguished set of individuals who have accepted our invitation to be part of it. We have Ms. Pinky Anand, the Additional Solicitor General of India, a senior advocate of Supreme Court of India, a very distinguished graduate of the Faculty of Law, University of Delhi, as well as Harvard Law School. We have Mr. Mohammed Khan, the Additional Advocate General of the State of Chhattisgarh in the Supreme Court of India, a distinguished lawyer, somebody who has held fellowships in India and abroad, and has been working in the field of administrative law, constitutional law, and criminal law for many years. I also want to extend a warm welcome to a very dear friend and colleague, Professor Stephen P. Marks from Harvard University. Professor Marks is a professor at the Harvard School of Public Health. He's also the director of the Francois Boas Center for Health and Human Rights. His work is in the intersection on public law, public health, human rights, particularly international law, international organizations, as well as international politics. I also want to extend a warm welcome to Mr. Rahul Mehra, who is a distinguished lawyer and is also Delhi government's counsel. He's also a law graduate from Delhi University, a practicing lawyer in the Supreme Court, has been working on issues related to sports law, has for many years been a voice for advocating accountability and transparency in the functioning of many sports organizations, including Sports Authority of India, as well as the BCCI. And also I have with us Ms. Geeta Luthra, a distinguished senior lawyer, senior advocate in the Supreme Court of India, a graduate of Lady Shri Ram College, Delhi University, as well as the University of Cambridge. Ms. Luthra is another distinguished lawyer, an awardee. Both Pinky and Geeta Luthra have been awardees of the INLAC Scholarship. I would like to extend a warm welcome to all of you. As you can imagine, this particular situation that we are in has created significant amount of concerns among individuals about the very nature of the rights and freedoms that we cherish so much. I would like to begin this first question to Ms. Pinky Anand. Pinky, there are numerous challenges that we are facing today, but one of the big challenges and concerns among the minds of many people is, how do we ensure that we strike a balance between rights and freedoms during emergencies? To what extent our civil liberties need to be protected, and to what extent the balance can be achieved in this process?
Raj, I think you have raised an extremely interesting issue in the current times. I mean, the current times are trying times, and we are facing this pandemic, and we are facing all sorts of new situations, both in law as well as in social framework. So within this, to talk about civil liberties is a very important feature. Yet at the same time, I think you have somewhat answered your own question to say balancing. The whole feature, I think, in this entire exercise is a balancing. But before I go even onto balancing and onto this coexistence of different rights. One in the rights in respect of the current pandemic, as far as the public health issue is concerned. Of course, Stephen is an expert on public health. And the second, as far as the rights, civil liberties of people are concerned. I think I am very enamored with what I recently read, Snowden's article, who wrote about Salus public law. Health is a supreme law, and all else follows it. So I think to talk about other rights at this time, I'm not saying it is something which is not subject matter of this issue. But at the same time, considering the pandemic, possibly for the time being, there is complete overpowering of the concern, which is of a larger public interest. And if you go down to some of the judgments of our courts also, in fact, modern dental, which dealt with health issues, but in the context of education, nonetheless held that, basically to see from the interest of the general public and not from the perspective of the people upon whom, let us say, the restriction has been imposed. But having said this, of course, we have to ensure that each of the impositions which is made, which is constitutional, Constitution itself, while Article 19 is there guaranteeing all the fundamental rights, itself grants a state the right to pose restrictions. But to what extent the restrictions are to be posed is the question. Now, for example, in Puttaswamy's case, you really had the outlining of the limits of what you could do and what you should do. So first is legality, second is the legitimate aim and object of the statute, and the third, by and large, is proportionality. And I think there is almost no question that most of the impositions that were imposed within legitimate exercise of a state object and state object in the larger public interest. But having said this, you find that even that has been phased. It is not a single development. So you have now 3 phases, for example, in India, and the 4th phase, which is coming from 17th onward, which is of course going to be announced, and it has already been, some statements have been made yesterday by the Prime Minister in that respect. So you have to take care of basic rights of people, and those basic rights of people is what the government has been looking at very closely and trying to ensure it. Nobody can ever be perfect, particularly in a time of crisis. But at the same time, whether it is the wages, whether it is the salaries, whether it is sending the migrant workers back to the states, back to their homes, an entire mammoth exercise. 3 lakh migrant workers have already gone back home. There are about 4 lakh migrant workers. You are ultimately, the whole provision at the first instance, first phase itself, was providing food, ration, shelter. Again, as I said, some people may raise some questions about the kind of services provided. But nonetheless, I have been talking to people, aside from seeing the newspapers and the reports. People are getting these rations. For example, everybody has got rations free, double the rations, and they are being able to utilize, at least survive with that basic minimal that is being provided by the government. Or for that matter, people who were in shelters, as I said, you will find some gray areas where possibly there was some scarcity at points, but then people have covered up, NGOs have covered up, we have covered up, people like you, me, various people have stepped in, civil society has stepped in. So what is the human rights that you would talk about, the civil liberties? You can't have a right to move when there's a lockdown. The lockdown is not for purposes of anything but of ensuring a contactless or a social distancing, which is by any means, I don't think anybody can or would question that principle of what it is. The other issue would be of what you can do. You have access to justice. You have access to justice. And in fact, you please see, we are all lawyers, so are you. So basically, you have this position where you're able to access the courts, at least in very urgent matters. And I must say again, courts have fulfilled a very nice and noble task by ensuring that there is minimal interference in any sense, and there is complete coexistence between what the government policy is and what the courts are looking into. So I think on a larger platform, if you see, you are having all concerns for the time being, if I may say so. The concerns of the individuals are the concerns of the state. And that thing is where that.
Thank you so much, Pinky. And I think you made a very strong argument about the role of the state and the role of laws. I want to take this to Rahul. Rahul, you heard Pinky, and towards the end, she did mention the word migrant workers. Look, when you look at the situation, there have been countries which have closed their borders for migrants seeking refugee and also asylum. This has also been observed within countries. And I think it is a telling tale of the way the migrant workers have been significantly affected in India itself. It's not so much that the governments didn't care, It's not even so much the fact that people were insensitive, but the real question is to what extent we can only depend upon the benevolence of governments to protect rights and freedoms of migrant workers. And is it time for us to really put in place a stronger and a more powerful legislative framework so that whatever has happened to migrant workers doesn't happen anytime in the future? Rahul.
So, Raj, first of all, thank you for having me over. It's a privilege to be sharing the webinar with all of you. I think to straight away come to your question, the answer very much lies in the question itself. I don't think anybody can argue that migrant workers were the most affected during this pandemic. Migrant workers have been shortchanged. Quite appalled to see that, how decision making was done. And this is, I just want to step back and not make this, in a very apolitical manner say this, that, a country which has 1.3 billion population, how can you within 4 hours say that, we will have a lockdown, a national lockdown? Surely at that time, when, 23rd of March, if I'm not wrong, at 8 p.m., the Honorable Prime Minister, with the best of intentions, and I think it was required, nobody can argue. I completely agree with Ms. Anand that, obviously this was the need of the hour. Lockdown was supposed to be there. The entire figures show that, it's really worked well for us so far. But, two things come to my mind. One, this was the harshest coronavirus containment measure in the world. It's a 1.3 billion population put under lockdown, and only 4 hours is given for the people. Now, I'll give you certain examples. What happened to the entire industry, which actually had all their supplies in the pipeline? You've not given them ample enough time to actually even look at that aspect. Coming to the migrant laborers, surely you knew that, people from various parts of the world, of India, actually travel across the length and breadth of India, especially from UP, Bihar and other states. And they are the ones which are actually the backbone of the economy of India. Nobody, with a heavy heart, I have to say, nobody looked into it. Even states have blocked borders. Can you believe that? I'm a citizen of UP, Bihar, Delhi, or anywhere else. How can states be so cruel and heartless that you actually close borders, that coronavirus is going to enter your city or your state? So one is that there was absolutely no preparedness. Two, that there was no advance notice given. Even in the second lockdown, if you see, there was no advance notice. So one is that preparedness. The other is that in a country like ours, I think the most vulnerable must have the prerogative over the state resources. So in that sense, the state does protect the vulnerable and the weakest section. And you see in the graphic manner in which people were on the highways, people were stranded at bus stations, at railway stations, at bus stops, and different parts of the country, saw those horrific scenes. Recent figures, which I read up in one of the articles, the total number of workers in India are 461 million is what the number is, approximately 461 million. Out of that, about 92 million belong to the about 49 million are informal workers, 2 million in the formal sector, 49 million in the formal sector, contractual labor or temporary staff. About 43 million of these workers, 10%, belong to the formal sector with some security of employment and statutory protections. Now, the lockdown has completely, decimated the livelihoods of these people. With the work sites collapsing, self-employed people completely sniffed out, supply chains have been choked, farmers have been affected in the worst manner. They are in utter despair, and so we are now witnessing a mass dispossession of working poor in the country. And the primary duty and the responsibility, according to me, lies with the state and the courts to safeguard against all of this. State obviously must come up with best policies, and those policies must be checked in the court of law. And I must say that the courts have been, especially in Delhi High Court and Delhi courts in the Supreme Court as well, I think we are well versed with it, and there is still a lot of infrastructure which is technologically very savvy. But I really don't know how we are coping up with various other parts of the country where probably the technological advancement is not as much. So all I want to say is there needs to be a humanitarian package for people. There needs to be a heart which needs to be shown. We need to come out. And yesterday I was told that we all heard the Honorable Prime Minister saying that there will be a package for everyone. I hope the vulnerable and the most affected are the migrant laborers, workers. They are the ones in whose bank account direct money should go into. Otherwise, in a country like ours with the disparity ever increasing, it could really be really bad in the days or the months to come, unless and until we really shake up and wake up ourselves right now. So all in all, we need to handle the migrant and the contract labor in a very delicate manner. This issue is delicate, and in a democratic and a consultative manner, where everybody, all stakeholders, including all states, are looked into, their concerns are taken on board, and then we address it in the most amicable and the efficient manner possible.
Thank you so much, Rahul, for that. Geeta, let me take it back to you. One of the things that we are today facing is that maybe the option, one of the things that we are facing, this question is for Geeta, maybe the options that we are facing today with governments are so few options in terms of what needs to be done, given the extraordinary nature of the crisis. So my question to you is, what kind of constitutional protection that are currently available so that we can respond to this crisis in a better manner? So to deal with this crisis, how should law and the courts respond to it?
So I feel that, one, the courts have not responded to it much, that I'm happy that the courts are trying to put something together. The fact is, I feel, first let's look at the migrant workers case, and one case of choker filed by Prashant Bhushan, another case filed by Mandir. The fact is that the courts have basically gone by the center's policy, saying that the center is saying we are taking steps and we are very happy, we want to take steps, we'll look into further grievances and we'll redress them. Now, this reminds me of Justice Krishna Iyer's judgment. I don't remember the judgment, but I remember what it said. It said that you have to be monitoring it. You have to keep what the court, even in cases like this, the courts have to keep looking and seeing what further can the state do. So in a sense, you act as a watchdog. Now, the effect of a watchdog is that the state in any case is doing what it's doing, but it will keep its act together and act far more promptly. No one for a minute is saying that the state or the center is not doing something, but it's very late and it's very slow. As Rahul said, and I really think that that is the crux of the matter, 4 hours before you announce a lockdown, none of our state machinery is in order. Supreme Court on the Disaster Management Act 2005, when 2013, I think it was the Uttarakhand matter which came up, said you don't have your act together. So if 2013 the act was not together, the fact is today we are even more taken by unawares. 4 hours later, if you are having a lockdown and we don't have social workers, volunteers, police, maybe even political leaders at the very nascent level, warning those migrant workers that this is not death, then they wouldn't have been fleeing in this manner. So the question is, what can you do? I feel that the Supreme Court will still get a chance. The Supreme Court should come in. The Supreme Court should monitor, because according to me, even interstate issues of one state not allowing another person to go to another state is something which Supreme Court can redress in a minute, which otherwise They will be pointing fingers at each other and showing their statistics as better than the other state. So we can't just close our eyes to the fact that there are 16 people who've died on a rail line in Aurangabad. Why did they die? They died because they were too exhausted and they crashed there. So we don't only need to give them food, we need to give them a place. And there are people who need to travel 15 days to reach their homes. So what do we need to do? We need to have rail lines or bus lines coordinated by various states. And I think it's true, these are policy matters. The states should be acting. That is why we have a Disaster Management Act. But somewhere we have to put our act together, and there's a lot that can be done. There's a lot of pitfalls which the Supreme Court could monitor.
Thank you, Geeta, for that. Let me move to Mohammed. Mohammed, I'm conscious of the fact that in this panel today, we have 3 lawyers who broadly represent different political parties. Although I would like to believe that this conversation should be based upon each one of you being a lawyer. The question that I want to ask you is that, is the heart of the problem is not so much the corona crisis, but the fact that we have been by and large, let's say, indifferent and callous about the plight of poor people? Isn't it the fact that crises of this kind exacerbate so significantly the deeply embedded norms of institutionalized and lack of inclusion that is deeply embedded in our society? If that's so, should the focus for us should be that we should really have a stronger social security legislation so that such forms of vulnerability can be reduced in the future?
A crisis is essentially an opportunity for us to introduce ourselves to us, our government to us. There are several examples where people have actually come forth and they have demonstrated enormous kindness. People have risen to the occasion, right? Whether it be average citizens, whether it be civil society, whether it be certain state governments or arms of the central government. But the question that we are discussing here today, I think, is focused on the role of the law and the how do we ensure that civil rights endure in a period like this, a period of crisis, right? A period of emergency, a period of constitutional crisis is a great time to understand how resilient our institutions actually are. And that is what we've been witnessing over the last 2 months, I would argue. I would say, for example, as Geeta ma'am pointed out, that the courts could have done more. But as Pinky ma'am pointed out, they sought to strive for a balance, right? Now, there are merits to both approaches. But then we come to, if I recall correctly, I think it's a quote attributed to Benjamin Franklin, that those who give up a little bit of temporary security to secure a little bit of freedom, temporary freedom, deserve neither. So I would simply say this is our watershed moment as a society. What is the extent to which we are willing to abdicate civil rights? What is the extent to which we are able to say that, look, we have to decide for society as a whole and not the individual? And that, I think, is not the job of the government. The government has to make policy which keeps in mind the Benthamite standard, the greatest good of the greatest number. It is the responsibility of the courts, right? And as Geeta ma'am said, we've seen remarkable examples from the various high courts and the lower courts, particularly over the last 2 months. I remember a very beautiful example was of the Delhi High Court. Mr. Mehra will remind us, where Justice Pratibha Rani, she pronounced a judgment protecting the rights of this very small infant who couldn't have access to treatment during the lockdown. So this family ran to the Delhi High Court and said, Pratibha Singh, yes, I'm sorry. So Justice Pratibha Singh ordered that this child be given treatment. Now imagine if Justice Pratibha Singh hadn't intervened. Imagine a situation like that. There, Justice Pratibha Singh chose to, or the Delhi High Court chose to uphold the rights of an individual as flowing from the Constitution. We have other cases as well. 2 from the Karnataka High Court, 2 excellent judgments from the Bombay High Court with regard to police action or excesses in police action. We have a judgment from the Bombay High Court on what constitutes fair quarantine. And they show us what our judiciary should aspire to be. Because remember, whenever courts, or all of us actually in a manner of speaking, when we hold these discussions, we are holding it to sort of add to the rubric of the law as it exists, right? and so that the future generations that come have a sort of template to draw from. And this is a time for us not only to aspire to high ideals, right? It's very easy to aspire to high ideals. We all do. It is very hard to practice them, to put them into practice. And it is especially important at a time like this, at a time of crisis, when you have every possible excuse not to abide by those protections, to actually go ahead and say, no, this is where we draw the line, this is where we will not budge. Now, Geeta ma'am made a very good point, right? We have seen over the course of the last 2 months, a number of PILs filed before the Supreme Court. In fact, the Honorable Law Minister actually said that perhaps people should not be misusing that route. And maybe there was value to what he was saying. But the problem is, where do people go? People go to the Supreme Court because that is the most visible forum that people see as an avenue for justice. And unfortunately, with one exception, that was the tests one. You remember the judgment where they said the tests will be free and then they modified it later? On all the other occasions, they have refused to intervene. They've simply said, no, we trust the government. Of course, it's good to trust the government. And I'll conclude this point by coming to something that Mr. Mehra said, which is very, very correct. Trust your government, of course. But does your government trust you? Mr. Mehra rightly pointed out that our government announced a lockdown with a 4-hour notice. 4-hour notice, right? Now, that is treating your citizens with a certain degree of suspicion. I will not get political at all. That is a different subject matter for a different forum. But that is correct. The government must also do its part to protect civil liberties and rights. I'll conclude with one more example. In the very first week after the lockdown, there were multiple reports about police excesses, right? Without court supervision, so certain members of the police force went overboard in different parts of the country. And different states responded to that challenge differently. For example, Delhi acted immediately, Punjab acted immediately. They called, they did what they could to assure the citizens that, no, ultimately we are here to serve you. And that, I think, those are the kind of challenges that we have to look at going forward.
Thank you so much, Mohammed. Thank you so much for that. Steve, let me come to you. I mean, when you when you have 4 Indian lawyers speaking about the role of courts and how courts have a very big role to play in this. At some level, we have enormous trust and faith on the ability of our courts to even contribute towards governance. As a law professor, I have my own doubts about it, be that as it may. First, I would like you to help us understand the international human rights and international law framework with regard to dealing with emergencies. Because one of the things that is being talked about here is that emergencies, as much as they are exceptional in nature, calls for exceptional measures, including, to some extent, suspension of certain rights and freedoms. So what ought to be the test in relation to its measurement, whether those things are done in a manner that reflects and even ensures India's adherence to international human rights obligations?
Raj, thank you very much for giving me the opportunity to learn so much from these very distinguished legal practitioners. And of course, I have nothing to add to the application of the Indian Constitution. I'm observing this and learning from it. As we're trying to learn, and I say we, and I'm going to define that in a minute, are trying to learn from the emergency declarations that have been made by some 84 countries around the world in response to COVID-19. And I say we because I'm a member of the Human Rights in Times of Emergency Subcommittee of the International Law Association. We have been grappling with the issue of what are the conditions under which human rights can be suspended, set aside, in order to respond to public emergencies threatening the life of the nation and the vocabulary of international human rights treaties. And in the course of my making presentations to various meetings of this committee, I've been arguing that health emergencies have emerged as something critically important that has not been adequately addressed in the international human rights framework. And lo and behold, then came the coronavirus. And here we are confronting it. So we need to go back to basics, but we need to adopt them to the current realities. The basics are essentially, and this is in case my voice is distorted or my accent is not understood, just to give a few notes for people to look at. The conceptual framework in international human rights is to apply the concepts of limitations and derogations. Limitations and derogations have been built into the human rights framework. Now, let me first of all step aside a minute and say, every country, as we've seen from the 4 other panelists, addresses the local situation in light of in light of the Constitution, in light of the functioning of the courts, in light of the traditions. And we know in this case, we're seeing this vast array of positions taken by China, by the United States, by South Korea, by the Philippines, by Brazil, and so on. Each one is different, but each one is grappling with the same fundamental balancing of preserving national security that can include public health in times of emergency and the rights and freedoms of individuals. So the concept of limitations and derogations has emerged in international human rights to accommodate that. And all legal systems have that. And all legal systems are supposed to come under international scrutiny. Yes, India is going to do it under the Indian Constitution, Article 19. Yes, the United States is going to do it under the Bill of Rights. Yes, China is going to do it in China's way. But there are international standards of limitations and derogations that are directly applicable here. There's one other thing, and I know my time is going to run out quickly. There are several organizations that are attempting to keep track of what's going on worldwide. This COVID-19 Freedom Tracker has, and this is an interactive map. So if you go to the website, you can find out for each country. 84 countries have declared national emergencies due to COVID. 30 countries have taken measures that affect freedom of expression. 111 countries have taken measures that affect freedom of assembly. 27 countries have taken measures that affect privacy. So these measures that are taken by countries balancing the problems that you have just been explaining so brilliantly with respect to India have to integrate the principles that have emerged of, and I think Geeta and Pinky both mentioned this, of necessity and proportionality. Rights can be restricted, can be limited in order to respond to public health needs as long as they are required for that public health purpose, they are necessary and proportional. The second category, and I'm going to conclude with that, is that of derogation. Countries have the option to declare a public emergency threatening the life of the nation. When they do that, they can derogate from certain rights, not all rights. They can derogate from certain rights in order to meet that public emergency threatening the life of the nation. So that wonderful statement that Mohammed alluded to by Benjamin Franklin has, and now I do promise this is my final point, by Benjamin Franklin has been picked up by the right-wing people who are mobilizing against the lockdown in the United States. And here is your statement from Benjamin Franklin, that even though we admire Benjamin Franklin very much for his contribution to understanding the nature of a liberal democracy and a constitutional democracy, this is a greatly misunderstood statement, especially when it's presented in the context of those who are protesting against the legitimate measures that have been taken to protect lives and are claiming that giving up a little liberty to gain a little security means you will lose both. That is not true. The whole regime of limitations and derogations is designed precisely to maximize the respect for the rights and freedoms of individuals with the necessary measures the state must take to contend with a national emergency threatening the life and health of the nation. Thanks, Raj. I'll stop there.
Thank you so much, Steve. Well, thank you for that. I think it was important for us to understand the international human rights framework. Let me go to Pinky. Pinky, one of the things that has been quite remarkable about the way India has handled this crisis is the fact that we've had far fewer cases and significantly lesser deaths as well. If you look at a country like United States, which has so much of resources, one of the most developed countries in the world, we're looking at 80,000 plus deaths already, and it is likely to increase as well. So there is nobody who's worth his or her salt in the scientific community would in any way argue that the lockdown hasn't worked. That's not the issue here now. The real question for us as lawyers is, if we were to do what we are doing in relation to lockdown, what ought to be the legal responsibilities for institutions, including government, to ensure that the most vulnerable among us are not adversely affected? One of the remarkable things that we have seen also is that the government did try to send a very important signal, which is to say that no less than our prime minister spoke in a very compelling manner, asking the employers not to fire their staff, encouraging people to protect the employment of the workers. In a way, my question to you as a lawyer is that enough? Can we only depend upon the sort of exhortation of our leaders, which will, and hope that protection will emerge through that exhortation?
Raj, I wonder where we are going with this actually. What can and what one should do? These are the two issues that we are discussing. So what do you have in terms of civil liberties? As you said, some of us have also spoken on that. You're talking about the vulnerable sections. So in a situation, you have two situations. You have government employees and you have private employees. As far as the private engagements are concerned, they are not really subject matter of what the government can compel. But at the same time, what the government did do, and I think we have till date issued about 48 odd advisories, which includes inter alia payment of full salary to people who are engaged in work or who have been unable to work because of the lockdown. It includes the issue of payment as far as rent is concerned, of not throwing out people because they were unable to pay rents, particularly students and workers. So you have taken care of what ultimately at the bottom of a line, when you're talking about a crisis such as this, the public issues that could arise and do arise are not definitely a movement or of assembly. I mean, those are not the issues which are critical or germane to the current conversation. What is it? Roti, kapda, makan. Roti is also, I mean, the kapda has also lost its significance at this point of time, in the sense, basics, yes, but broadly beyond that, no. You are talking about these three ingredients, and what government has tried to do at all levels, these issues and either the mandatory work, such as packages are concerned or incentives are concerned or Jan Dhan scheme is concerned. I mean, monies have gone into people's accounts, and that has been one of the grandest schemes which the government had at one stage done. Again, at the time of the second phase of the lockdown, the agricultural sector was opened up, so much as farming supplies and other things were opened up. So you have the government chip to ensure that the people are able to get their basic necessities and to ensure that they don't suffer the negatives of lockdown. Yesterday, you know, the Prime Minister had announced a 20 lakh crore package for MSME sector. The question is, this is my belief, very sincere, that you have to take the entire issue on a canvas. And when you take that canvas, there are some areas which are larger and which need to be coped with, let us say, if that is the right expression, or catered to. And at the same time, there'll be the fringes also. So I am not saying that everything is not important, but it's a question of grading the importance of everything. And yes, you will always find in any of these gradations, there will be losses, and there'll be losses which call them legitimate, call them illegitimate. And the third part I want to make, I do believe very strongly that when we talk about disasters, and I'm talking about whether you have this, September 9/11 disasters, I do know that when disaster comes, we also should have a code to address, and there is in some of the countries, you have a code whereby you actually are not allowed in that sense, or you're prohibited also in some cases from actually demonstrating the negatives of a disaster. You have to always try to put the situation further up. Now, just on the point, everybody is talking about, a lot of people are talking about migrant labor. I mean, one understands, but I must point out to you, by the way, when we're talking about this legal framework, I didn't mention it earlier. The Interstate Migrant Labor Act is there, and actually it exhorts the states to evolve policies to take care of such situations, not such as in the current situation, but of migrant workers, because migrant workers, as you rightly said in the first initial part, they actually move from state to state or go back home, etc. Those are considerations of whose liability in that sense it is to take care of them. The states were to make policies. In fact, those policies haven't been made. And incidentally, this matter is in court, and the court was looking into it to say these policies should be made at the earliest, so that in such similar or other somewhat similar situations, the migrant labor should not suffer. But in the meantime, aside from the 4 hour, yes, you can say it could have been 4 hours. Whenever a line is drawn in terms of time, if it had been 10 hours, if it had been 24 hours, would it have made the situation better is a moot question. I don't want to go there. Nobody can go back in history and kind of turn the clock back. But at the same time, you did have a crisis on hand whereby you had to prevent contact, you had to prevent, you do have financial resources, you do have each of these issues. So as I said, there may have been some gaps in implementation at points, but at the same time, people were given shelters, people were provided food, and people were provided with healthcare facilities. And gradually, as time went by, they were provided other things. 302 trains have taken the migrant workers back, and you find about 3 lakh migrant workers who've gone back to their homes. You are even having from yesterday onwards, you're having the AC train, which have been put into operation. So, the whole provision, you had the Vande Mataram, where you have all the 64 countries which were covered in the first phase, you have the second phase.
Thank you so much, Pinky, for that really comprehensive tour de force on the efforts that have been taken by the government in relation to this. Rahul, I want to shift gears a bit now. One of the things that has happened in relation to the crisis is that the role of the government has actually increased. I mean, at one level, there was a very natural tendency for governments around the world to recognize a much more limited role for them, but this crisis has actually created a more expansionary role of the government. So how do you think issues relating to surveillance and cyber policing and also potential, let's say, intrusions into privacy? Now, for example, there are very good intentions for, let's say, this Arogya Setu app that has been put forward with a view to, create, let's say, develop a better awareness with regard to the disease itself. To what extent, more broadly, privacy is a matter of concern now?
So, Raj, obviously this is of paramount consideration. Right to privacy is a fundamental right, as in Puddaswamy, the Honorable Supreme Court, the 9-judge Constitutional Bench has already laid down that law, and that is here to stay. And I'm grateful to the jurisprudence of this country that we respect our privacy. And if we actually go back to 1976, and I want to actually just draw your reference there and then come to the Arogya Setu. Arguably the most controversial decision ever, and probably I would say with all humility that the darkest hour of Supreme Court has been the 1976 ADM Jabalpur case, which is also popularly the habeas corpus case. Supreme Court unabashedly agreed with the government's submission at that point in time and declared that even the fundamental rights, the 5-judge Constitutional Bench at that point in time, in a majority decision of 4:1, said that you can't come to courts even if it is right to life, liberty, limb, whatever else. And whatever the state does, you got to live with it. In 2017, obviously that was done away with, and the son, Justice D.Y. Chandrachud, authors it, and as sets aside his father's Justice Y.V. Chandrachud's judgment. Now, so there is absolutely, the jurisprudence in India is there is absolutely no question of suspension of fundamental rights, of civil rights, including Article 21, even during emergency of any kind. Now, let's come to the issue of Arogya Setu app. We need to understand that it is only in times of fear for survival that we as a society often give up our freedoms, and we give it up willingly, like we are willing to do it right now. There is a fear psychosis amongst Indians. There is a fear of the unknown devil, and therefore, okay, let's give up with all our freedoms. Let's cage ourselves inside forever. That's not going to solve the problem. We need to address it. We need to obviously be cautious. We need to follow all the good principles. We need to be maintaining social distancing, but we need to open up, and we need to ensure that the containment zones are the ones which are actually taken care of. Now, Arogya Setu, unfortunately, it completely violates the right to privacy. This is not a good trend. It removes all the checks and balances which are actually inbuilt in a democracy and should be inbuilt in a democracy. A mandatory use of Arogya Setu app for almost now, I'm told there are 100 million people who have already registered themselves on the app. Look at what happened to Aadhaar. All the data was actually leaked. And there is not a single person who has held accountable so far. Similarly, in this case, if the data gets actually leaked out, or let's say data is used for some other cyber policing or for some other kind of issue, then what happens? So there is, what we need to do is we need to take a step back. We need to see that surveillance is the worst remedy. In fact, COVID-19 has very, somebody very articulately said that it's a gift to authoritarian states. So, India really doesn't have any meaningful anti-surveillance laws. Neither do we have any effective privacy and data protection laws. We go back to 1885, the Telegraphs Act, to deal with situation. The nationalist government, which is in power with unprecedented snooping powers, lack of effective laws, the real and very serious authentic fear is that there could be tomorrow sinister implication of this. So the genuine concern about Arogya Setu not being even actually having a legislative or a statutory backing is something which must concern all of us. Now, I would like to just say, with Arundhati Roy, the author, very aptly said, she said in the pre-corona time, we were actually sleepwalking into the surveillance state. And in the post-corona, or actually during the corona right now, we are panic running into the surveillance state. So this is something which we should be very, very concerned about. Even Justice Shri Krishna, who was the first draft, he was heading the committee of experts for the first draft on personal data and protection bill. He has recently said that this entire Arogya Setu app, which has been made mandatory in various states, including railways now, has absolutely no statutory basis. So there is huge amount of ambiguity about it. Yeah.
Thank you, Rahul, for that. Geeta, so one of the things that is emerging clearly from the discussion is that, technology will inevitably need to be used for various aspects of the work that we are currently going to be doing. But at the same time, use of artificial intelligence and other technology-enabled platforms will inevitably pose certain challenges and risks associated with the kind of privacy concerns that Rahul and others talked about. So then the question is, does it all boil down to the trust between the citizen and the state, or we can try to create institutional mechanisms and legal mechanisms so that the use of technology for what we need to can go hand in hand while people are confident still that their privacy will be protected. In some ways, I believe, and correct me if I'm wrong, online and e-based adjudicatory process will have to expand as we look at the future of this crisis. At the same time, we also need to figure out how do we protect privacy.
So according to me, can we trust the state? That's the first part of the question. We cannot trust any state. Power corrupts, absolutely. So without casting any imputations on the state or on the center, the fact is this is part of a political philosophy. You cannot have powers which are untrammeled and unbridled. Clearly, the surveillance which is being done does not have a statutory basis. Even if it's done under Section 6 of the Epidemic Diseases Act, and for the states it's done under Section 2 of the current Act, 2005 Act. Fact is, it doesn't have a statutory basis. Is it legitimate? Is it something which has a legitimate basis? True. It does have a legitimate basis. Is it proportionate? And that it isn't proportionate because you're giving unbridled powers. You're not having any restrictions. You are imposing it on the people without their consent. So the first issue is, what if the people consent to it? I think if people were to consent to it, and if there were enough precautions or safeguards, there was nothing wrong in it. But it cannot be a shame and blame game, which is you can't be having people named, posters put out, people, because ultimately there is an element of witch hunting in this. People feel, oh, so and so has it, and so there becomes an element that somebody, even though they've got it as innocently as anyone else, it becomes a subject of a witch hunt. It becomes a subject of a hate kind of conduct. So we have to be very cautious, and the state has to be very cautious in this respect. And that's why I'm saying we can't just go by trust. Coming to the second part of what you said, what can the courts do, and can we have e-courts, and how effective are e-courts going to be? So we can see that this is going to stay for another 2-3 months. Now, what I'm seeing is that, say every Monday, Friday, you had 600 to 1,000 matters in the Supreme Court. Take Delhi High Court, you had probably 3,000 to 5,000 matters. You are having a smattering of matters. So we are really not being able to even address anticipatory bail, personal liberty, habeas corpus needs. While Mohammed was talking, he said that there was one case in which Supreme Court had done, in the testing aspect. I thought even in the 7-year anticipatory bail issue, saying that not anticipatory bails should be granted to persons who are under trial or convicted of 7 years and below, and who are awaiting appeals or who are under trials. Bail should be considered and committees should be formed. Now, I think even that aspect is something which is worth appreciating. We have to decongest jails. Now, the e-courts, I think the e-courts cannot be the final outcome. They can be an interim outcome. They may be finally a partial outcome, but for trials, but for hearings, but for oral hearings and serious matters, you would need the courts to get back into their earlier mode, maybe a time out that mode.
Thank you so much, Geeta. Mohammed, I want to come back to the point about what Geeta, where she ended in terms of e-courts and adjudication. You see, one of the things that is taking place is that, while you mentioned briefly about the fact that courts in the capital seem to be functioning and probably at the higher level, but the administration of justice across the country is a major challenge. So do you think that the current situation is, should the Chief Justice and indeed the Supreme Court provide greater leadership for ensuring that the broader administrative justice agenda across India can be expedited, and in that process, use of technology at all levels need to be encouraged?
I think that's an easy answer, Professor. The easy answer is yes, absolutely. We look to the Supreme Court and to the Chief Justice for guidance. And from the very beginning, it is the orders of the Supreme Court that have sort of laid the groundwork for high courts. The Supreme Court was the first to adopt video conferencing technology, and the other high courts followed suit. Geeta ma'am very rightly pointed to the March 23rd order, where they said that prisoners who are under trials or for non-heinous offences should be considered for release. Ma'am is absolutely right. But I want to go back to a question that you raised, Mr. Mehra, with regard to the Arogya Setu app. And it's very important to consider the Arogya Setu app in the context of the history of this litigation from the tenure of the last to last government. Now, you remember when the Aadhaar was first introduced, it was struck down. It was struck down by the Supreme Court because the court said It has no legislative backing. So a new government comes in, brings in a law. Very good. Note that the Arogya Setu Act does not have this law in force. Even by that standard, it falls short. Number two, let us consider the legal history. In 2018, Professor, you will recall that perhaps for the very first time in any nation's history, a government stood before the Supreme Court in black and white on an affidavit, argued that its citizens do not have a fundamental right to privacy. I quote, they said that the right to privacy is an elitist concern. This is in the affidavit. It was argued in court by the Attorney General at that point of time. It is a concern of the rich and the privileged. Thankfully, the court unanimously disagreed. 2018, there is another attempt to set up a surveillance machinery. Tenders are issued by the government. This is after the privacy judgment, the Puttaswamy judgment that Pinky ma'am quoted. That attempt is also squashed by the Supreme Court. Keeping in mind what happened in 2017, keeping in mind what happened in 2018, you cannot accuse us as lawyers of being suspicious or wary when we ask questions in 2020. And now that we have a legal regime, we know what the pillars are. One, as per the original Aadhaar judgment, you need a legislation. Two, you need a law on privacy, as per the Puttaswamy judgment of 2017. Three, you need a mechanism that it shows me that my fundamental right is protected. I will leave it to you to determine whether these three questions are answered in the context of the Arogya Setu Act. Coming very quickly to the second half of the discussion. We are talking here, this entire discourse has been about rights, correct? Rights in a time of crisis. And Professor Marx touched upon the idea of proportionality. Well, I think we should look at 5 examples very, very quickly, right? During the course of this crisis, well, I wouldn't call it a constitutional crisis yet, but during the course of this crisis. One, how has the government and the Supreme Court reacted to the suspension of labor laws? That remains to be seen. How has the court reacted with regard to the migrants who have come before it and said, look, we are having difficulty traveling? The court declined to intervene. 3, when people came and said we are being harassed by authorities, certain authorities, what did the court do? 4, when, as Mr. Mehra and you rightly pointed out, the questions over the last week about the right to what has the court done? And 5, when the rights of minorities were called into question, right? During a time of this crisis, what did the courts do? It's all well and good to sit here and debate about what the law should be, but this is what the law is. You just need to examine these 5 things.
Thank you so much, Mohammed, for that. Listen, I know this discussion is quite enticing for us to continue for more. I have over 100 questions from our viewers. I'm going to be very selective about it. Steve, I want to quickly ask you, one of the questions, and I know you're going to be, it's a much more difficult question for you. The question is, Professor Marx, you have lived both in India and US. From a legal and human rights standpoint, which country is dealing with the present situation better? So, Steve, you want to take that question?
No. No, let me try to transform that question into something that could contribute to the discussion, because certainly it does bring out an issue that I've noticed at least 3 people on the panel have explicitly avoided and excluded, and that is the politics. We are looking at this from a legal perspective. The fact is that politicians, especially populist politicians who pride themselves on their own personal charisma to get the job done, they think they're doing the right thing, and they have popular support to do that. Those politicians tend to address these issues from a political perspective. I won't speak for the government of India, but I can certainly say that it'll be difficult to find anybody in the United States who will not acknowledge that the behavior of the President of the United States is more political than engaging in an honest balancing of the issues that have been so well expressed here. Balancing, containing the crisis, containing the number of infected people and deaths at the same time as trying to limit the harm done to the economy and respect the rights and freedoms of individuals. So it becomes very political, and that is it should not in this case. Under a situation of crisis, it is not in the long-term interest of either human rights or public health that the issues of these delicate balances become politicized. And I do regret very much that this has been the case in the United States. And we see it particularly now with the demonstrations in favor of opening up certain states that still have the curve on the upward trajectory of infections and deaths, to open up the economy and open up stores and so on, and people demonstrating without masks and without respecting, and with the support, here's my point, with the support of the public support of the President of the United States. So who is contending with it better? One of the reasons that makes that extremely difficult to answer is that we cannot trust the numbers. It is difficult to trust the numbers even in the United States when we have outstanding institutions such as the CDC and the Bloomberg Public Health School at Johns Hopkins University and the University of Washington and all these wonderful institutions, say nothing of my own institution, where some outstanding epidemiologists are covering. China has outstanding virologists and so on who are covering this, and India has outstanding public health officials. But in each case, the methodology is different. How can we trust the numbers? How is it possible to have these low numbers in India? Oh, sure, you can say it's the heat. You can say all kinds of things that are scientifically dubious. The fact is that India can claim low numbers, can claim that that's because the measures taken are appropriate. But I can't compare it to the United States because the United States is turning out to be the country that is producing, that has been the least successful in containing the pandemic. And yet the resources theoretically were there to do a better job. So both countries have a lot to do.
Thank you, Steve. You did pretty well for that question. Thank you for that. Pinky, there's a question for you. Sumati Oswal is asking a question about whether there should be a mechanism to have fast-track courts to deal with certain urgent matters arising out of COVID-19, for example, because there are lots of force majeure type litigation. There are many other matters that are coming up. The existing mode of dispute resolution, as you and I know, might take far too long. So Sumati is asking, should we have fast-track courts for this purpose?
I think we are having courts dealing primarily, if not almost entirely, with COVID-19 issues. So therefore, this whole principle is that this is the very, very urgent category of cases. And therefore, I mean, some of the points made earlier, I do want to address that for a moment, to say when people have said that courts have not addressed these issues. It's not as if the courts threw out these petitions whole scale at the first stage. They were heard and then courts passed the specific orders. For example, in the case of prisoners, the kind of healthcare facilities should be done. Ultimately, the Supreme Court ordered even high part committee to be set up to look into various measures that should be there. So by and large, yes, two things. Fast track courts, very desirable, no question about that, because force majeure is an issue that is become extremely important. That's why you find, for example, limitation, etc., was extended by the Supreme Court in a reference, etc., on its own. So very important and needs to be dealt with at a category of regular litigation. Regular litigation category, I would urge all of us to look into very much, because the constraints of being able to not do action or supervening circumstances or subsequent events rather, which are frustrating the contract and situations such as this, is something which should come up for serious consideration.
Thank you so much, Pinky, for that. One of the questions that people are asking, and maybe Geeta, you can do, access to justice has become a major challenge now. So are these moments when should our justice mechanism should focus a lot more on alternative dispute resolution mechanism as opposed to expecting our courts to deliver all dimensions of justice? And what are the specific things that we can do for strengthening ADR? Several questions have come on that.
So actually, in a sense, ADR is better suited at this time, during the time of COVID-19. But very recently, I was talking about having one arbitration matter and trying to get it to continue, which is a matter prior BC, that is before Corona. And now, one of the issues there is that how do you record evidence? If there is evidence and if you have video conferencing, and I personally have had difficulty in two matters where we tried to do video conferencing. The expense was great, was a lot. We did it at the Warsaw Indian Embassy, and yet the person was not, a translation was not good, or the person was saying he couldn't understand the translation. There are lots of issues. Unless both parties are agreeing, let's go by affidavit evidence, or let's go by evidence which is not by affidavit, because you may not know what the other person is showing or passing on. But sure, till all this happens, mediation works much better in person, because the moment you are face to face, you can be more persuasive as a mediator. So although those alternatives, I mean, if you have no choice, it's better to have some resolution than no resolution. So it's better to go the ADR method, whether mediation or arbitration, than have nothing at all. And in any case, access to justice and the justice delivery system has become so overburdened that I think ADR is a good option.
Thank you so much, Geeta. Rahul, there is a question from Kritika Singh, who's asking about the issue of food security and the entire sort of right to food petitions that the court was handling before. To what extent those type of issues, resolving them at the right time through both institutional mechanisms and legal mechanisms, would have helped us to deal with this crisis better?
So we need to see it from the practical aspect as to how things have unfolded, Raj, over the last couple of months. I think all of us would agree out here, had it not been for the citizens of this country, who really always, they have never let down the nation. They've always lived up to the occasion. Had it not been for them, had it not been for the civil society and the various NGOs and who are doing phenomenal job, for the Gurudwaras, for various other institutions which have really stepped up. All the governments, and I have absolutely no doubt in my mind when I say that, would have absolutely collapsed in delivering to the citizen of this country. We don't have mechanisms, we don't have the heart, we don't have the compassion. Majority of us, actually, I can say that people who are in the powers that be lack that basic ingredient of compassion and empathy. There are some really pro people and pro citizen, and when I say people, I mean the real we the people who are the voiceless citizens of this country. There are very few leaders who really live up to the occasion and who really work and have given their entire life, the legal fraternity, to step up and to doubt every single order. I am saying start with doubting every single order, administrative order passed by the governments. Check them, put them functional, see whether it is only in letter or also in the spirit being implemented. And that is where the roles of the court is critical. Unfortunately, as I see it, some of the very critical issues which have been challenged before the Honorable Supreme Court, they have been challenged, but the court has not really tested their legality against the rights and have chosen to defer the executive decision due to the magnitude of the crisis that we face. That is something which we really need to address. And I think it's time is here that we need to open up courts. We need to actually give free access to people. Access to lawyers is not there. Forget about access to courts. If you get to a lawyer, will you get to the court? 95% of the people in ordinary environments can't get access to courts. Delhi obviously is more privileged. I can say that because I see it on a daily basis, how privileged we are to stay in Delhi. But I shudder to think what happens in the remotest corners of this country, where 75% of Indian population actually lives. That is where the problem is. And I think this is a wake up and a shake up call for all of us. We need to really get our house in order, not only the medical capacities and the facilities that we need to put in order, but also the infrastructure, the court, the e-courts, and the e-courts are very slow process. We need to actually now make them we need to stream, our live streaming of courts need to happen. Even in ordinary times, live streaming of court needs to happen. So all of that, those steps need to be taken. And I think Supreme Court and the Chief Justice of India is the one who has to take the cue and has to lead.
Thank you, Rahul. Thank you, Rahul, for those very valuable comments. There's a question for Mohammed from Shireen Moti. Mohammed, the question is in relation to what are the specific legal measures that we can put in place so that protection of marginalized people, particularly in terms of crisis, can be better responded to. In some ways, how do we go beyond the benevolence of state or central governments to deal with these type of issues?
Right, I think that's a very good question, and different panelists have actually answered it at different points of time. Let's start with, as Pinky ma'am said, roti, kapda, makan, right? Let's start with the basics: food and shelter, medicines. You cannot rely on the goodwill of your fellow citizen alone. Of course, that has been a major source of comfort during this time. But let us say, for example, go back to the food security question that you asked. The food security, the right to food security, the right to a confirmed entitlement of rice, wheat, and millets flows from a statute, which is the Food Security Act, the NFSA. Now, can we go to the court in this time and ask for its enforcement? In fact, this government has actually announced an entitlement over and above that. So then the question becomes, that's excellent. What do we do to ensure that that right reaches the people? So what do we need? We need data. We need to know that the people who are getting food grains in January are also getting it in April. And has there been a commensurate increase in April? For that, we need data. For that, we need transparency. And I think that is something that the courts should be inclined to give. In fact, coincidentally, we approached the Supreme Court last week with this exact prayer. And we were told to write to the Minister for Food and Civil Supplies, which we have done in the interim, and we are waiting for a reply on this point of data. The second question is, you have to divide them up into silos. There are laborers, there are migrant workers, there are small and medium scale enterprises, there is the middle class. Everyone has challenges that are peculiar and unique to them. And it is not the court's job to craft solutions for them. The court must ensure that the rights guaranteed to them by the Constitution are protected. It is the government's job. And there you can go to the court and say, look, there is an absence of feedback from the government, or there's a lack of clarity from the government. And could you ask them to provide me with this clarity? That has been a major use of it.
Thank you. Thank you so much, Mohammed, for that. Steve, there's a question from Jayashree, and this is a question which many people have asked time and again now. Is there a lack? We have been talking about national institutions and how we need to strengthen it. The question that Jayashree is asking is, to what extent there is near absence of the strength of international institutions in relation to this response that we are seeing? While WHO as an organization is making some contribution, why has the UN General Assembly not been convened? Why has the UN Security Council not taken cognizance of this matter? What are the possible legal obligations that nation states have in relation to sharing information so that they don't create a risk and vulnerability? The big China question. Jayashree is raising all these questions for you to answer.
A very good question. I thank Jayashree for posing this question. Probably unknown to the public, even the educated public in India, the United Nations immediately stepped in to call upon states to respect their obligations under various international treaties and resolutions in this time of pandemic. And of course, in close collaboration with the World Health Organization, that has also endorsed and supported a human rights approach to implementing the international health regulations. There's an interesting mixture here that needs to be kept into account too. You have the international human rights regime on the one hand with its facilities for addressing situations of emergency, and you have the international health regulations on the other that provide for public health emergencies of international concern. So there are different rules that apply there. In both instances, the World Health Organization has intervened using a human rights approach to the implementation of the international health regulations as applied to this declared international health emergency of international concern. The High Commissioner for Human Rights has been very forthright in reminding governments of their obligations to respect human rights while addressing this issue. A rather remarkable statement was issued by the special rapporteurs. We call them special mandates. There are about 10 or 12 of them got together and issued a letter at the end of April reminding countries of their obligations to respect human rights as they are taking emergency measures to address this. The Committee on Human Rights, which is responsible for monitoring the compliance with the limitations and derogations provisions that I was alluding to earlier, has also jumped into the fray, issued its own statement on what needs to be done, and reminded countries. Now, all of that has been sort of at the area of wishful thinking that countries will take serious their legal obligations. The Security Council, on the other hand, has been urged to take up this issue and is beginning to do so, but has failed so far to take decisive measures to address this crisis. So you have, in a sense, the specialized agencies of the UN, especially the World Health Organization and UNESCO and the ILO, addressing the issue with the member states in light of their obligations. They've been forthright. The High Commissioner for Human Rights, extremely forthright. The Secretary General of the United Nations, we couldn't have asked for a better ally for a human rights-based approach to addressing this crisis. And then as you move towards the Security Council and the international financial institutions, you find it's much more difficult to get political will in line with the other institutions. The short answer to a very complicated question.
Thank you very much, Steve, for that. Pinky, there's a question from Maithili. This question is in relation to use of technology in relation to dispute resolution, use of video conference and other type of such measures. What Maithili is asking is that, would this use of technology in dispute resolution will further create new forms of gaps in the access to justice mechanism, whereby some disputes will inevitably get prioritized and a large number of others may not be heard?
She's put the question rather smartly, I must say, because while addressing technology, I think the selective process is something that she's outlined quite well. It is an area of grave issue with a lot of people who feel that this entire process of video conferencing has started a new process of selective hearing of matters, which basically means, as she says, quite in a sense, quite rightly, that there may be an issue of access to justice. Because the first thing is that you have to have your case put in that list for it to come up in the video conferencing to be heard, and that does limit the process. So yes, there are some issues and some glitches, if I may say, which are happening, and some delays or some limitations that are arising on the system. But I think as everything is, the whole issue is to deal with the current crisis as it stands. And that is how the system was developed. And I must say it was, and I must address Rahul's or Khan's statement. I don't across the country also, incidentally, district are being able to technology. And yes, there are limitations, and yes, there is some kind of selection, because very urgent matters, as somebody said, fast track courts. You talk about COVID-19 being the basis for fast track courts. So yes, for the time being, it has been so. But even as we talk today itself, for example, the Supreme Court has been talking about starting next week regular courts where the judges might sit in the courtroom. This is, of course, something only in the discussion process, and we haven't been notified. Another thing, for example, which has been done is dispensation of gowns and coats, because they are possible sources of virus containment. So there are constant issues, because this is not something that we had planned. In fact, I'll just quote one small article here to say this, that while we all talk about this being an event which is new, this article that I read implies that it is something that we should have contemplated, and in fact it has been happening. So epidemics, SARS, all these other Ebola, etc., which have been there, is something which was within the contemplation, and it was in the coming. There was a warning, we didn't observe. This is just shows that we must step back in time, so that we don't only address the current scenario. While we are addressing this, we try to cope up, as Stephen also said, basically, rightly, that we are talking about developing an entire system whereby we are able to address. So whenever we talk about systems created today, they have been created in a moment of, call it panic, call it addressing immediate concerns, call it urgency, call it the pressures of the situation. So it has been taken under those circumstances. Obviously, they could be looked at again, and obviously we will learn from these to develop systems even better.
Thank you so much, Pinky, for that fantastic point, where this is an opportunity for us to, be prepared, and to what extent our legal system is prepared for dealing with it. Rahul, there's a question from Mahavir Jain. Mahavir is asking about the Kashmir situation. I mean, he's asking, in Kashmir, we all knew that whatever happened before had created a vulnerable situation for access to a number of things. So the question is, what are your views on the crisis there, particularly when the region was already affected and the COVID crisis has exacerbated in many forms of access, including access to internet. In this regard, one of the things that Mahavir is raising is that today in many urban locations, schools and colleges and universities have gone online. In fact, our own university, Jindal Global University, we have completely gone online. But that's still a privileged opportunity. Imagine in places where such access is not available due to internet. How do we deal with that?
Yeah, so it's a very pertinent question, and I think Kashmir is one area which many of us are concerned about for many reasons. I think to address your second part first, accessibility to Wi-Fi, accessibility to a gadget, accessibility to to a laptop or any other gadget with which you can actually be privileged enough to attend an online session is a drop in the ocean. So I don't think we are even this is a very elitist and a very privileged conversation, at least in a poor country like India. Although within the framework of the also with the various limitations that we face with the various state administrations and the national government, I think we have in this crisis been able to somehow bridge the gap between complete blackout of education or continuance of it. Coming to the more important aspect, again going back to the role of the Honorable Supreme Court, and sometimes I feel like these are petitions. A habeas corpus petition in the state of Jammu and Kashmir, and even the Supreme Court refused to address for many months. This is again the judicial, the entire journey of ours and the jurisprudence in this country has been that the habeas corpus is the most important writs of all. And if in a country we can't address that issue, I think we need to do a lot of soul searching and a lot of the people who are actually sitting at places where they can make all the difference, they need to really get their act together. Secondly, I would say, when there was a petition in the Supreme Court which actually talked about 4G accessibility from the perspective of giving medical facilities to people, the Honorable Supreme Court again took its time and to address the issue. We can really say that people have been wanting that the judiciary should be right at the upfront, because eventually in a democracy, when everything fails, it is the faith of the common man in the institution, which is our great institution, which has lived up to the occasions more often than not. There have been those days when where the institution hasn't really got its act together, but then there are off days for every institution. So what I would like to just leave a thought with is that like the press, like the police, like the doctors, like various NGOs, lawyers, judges, and our fraternity, the legal institution, too must be treated as an essential service in any form of emergency, including the present one. We are a part of essential service. When everything collapses, it's the ordinary citizen who looks at us, and therefore, unless and until we actually may eventually win the war on COVID, but we may lose the battle, on preserving our democracy and protecting our human rights, and that is a huge concern for me. So I would actually urge our institution that, there are so many things that we can do, leaving the less powerful in the society to the mercy and the whims of the more powerful in our society will create a very inhuman and a dark society. And I really think that India is a great nation. We are great people. The 21st century, as the Honorable Prime Minister said, can belong to us. And I think we all, including our institutions, need to really put their act together.
Thank you, Rahul, for that. Well, one of the things which Rahul said, I suppose, will resonate with almost all of us, where administration of justice, if it is an essential service, then the key actors of that administration of justice, including lawyers and judges, need to be part of it. Geeta, there's a question for you. Vijaya Sudha is asking a question. She mentions about the plight of, let's say, agricultural laborers, carpenters, weavers, and many others. And the question is really that what should be the contours of a social security law in India? In a way, we have number of piecemeal legislation which touches upon different dimensions of a social security legislation. Is it time for us to evolve a comprehensive social security legislation? Geeta.
So what would you have in that legislation? So a leave on sick, where there is a disaster, then in that issue, there should be, say, a sickness pay, or a pay for, pay in which you are considered to be on leave. So that's one aspect. The other aspect is maybe you could have follow along the lines, say the UK seems to be doing, that they will pay 80% of the rental. It's a tenant and a landlord. I can't decide necessarily, unless it's a case-to-case basis, whose right is superior. So there could be a carpenter whose landlord is a very poor man who has only that source of livelihood. So the state would have to step in, and therefore all these would be part of an enactment. Maybe you have a coronavirus 2020 enactment like you have in the UK, in India. And therefore, one of the issues that bothered me was when the Supreme Court said that you have food, do you also need money? So the question is, of course, the person does need money. Food by itself is not sufficient. And we all, as Pinky said, you need roti, kapra, makan. So maybe they had to open schools, maybe they had to open public institutions for these workers, employees to stay if they didn't have recourse to a place to live.
Thank you so much.
I believe the state will have to take some steps.
Thank you very much, Geeta, for that. Listen, Mohammed, there is a question which is, I think, a very important question which just gets ignored in these contexts. Ritik Gupta is asking, when we are focusing on many aspects of, social and economic dimensions of the issue, some of the issues on account of lockdown has actually gained more prominence. For example, domestic violence, there has been a significant rise in, acts of domestic violence. Recently, we have also come to know that child abuse, particularly taking place in the home environment, has significantly skyrocketed in India. So how do you deal with additional forms of protection for the vulnerable people during these times when the larger focus on the legal system ends up being the big issues of our time?
Yes, actually, I think this is a question that Mr. Mehra would be able to answer very, very admirably. So I'll just make an attempt and I'll leave it to him. I believe the Delhi High Court has done some very, very good work in this regard. There are very, very vulnerable people, young men, young women, etc., for whom this lockdown has presented very, very difficult challenges. And here, I think the courts have been sensitive. I think there's a PIL pending in the Delhi High Court where this issue is being examined. I believe there are other courts as well across the country. I believe Bombay is looking at it, Karnataka is looking at it. In this regard, when it comes to the rights of the most insecure, there I think our courts behave admirably, right? That is their moment to shine, and I think the high courts do very well in that regard. So yes, these and not to undermine the role of civil society, because it is ultimately civil society that first brings this to the attention of the public and then brings it before a legal forum. So yes, I mean, it's a question that I think we would all be in agreement on. This is something that the courts have acted upon, will act upon, and this is something that I think the government also, I think the Home Ministry issued some directions after the whole boys locker room thing happened. So I think they're also looking into this. But yes, whatever we do is not enough. I think we need to do more.
Thank you very much, Mohammed. Steve, there's a question for you from Surya Gupta about the Sustainable Development Goal 16, which talks about peace, justice, and strong institutions. Now, one of the things about that SDG is that it expects leaving no one behind and reach the furthest behind first. In that context, to what extent that particular SDG goal is significantly undermined during COVID-19 times?
It's a very good question, and I would like to take advantage of it to link it first to the point that I was making earlier about the role of the United Nations institutions and the failure of the Security Council to address the issue head on. The Secretary General has been very forthright in addressing these issues, and then I'll come to the SDGs, but it's related to SDG 16 when the Secretary General campaigned really to try to utilize this pandemic, the COVID-19, as an occasion for all conflicts to accept, all parties to conflicts to accept a ceasefire. And this made a lot of sense. It is in the interest of peace and security that we address the constraints that are placed on all the institutions of society to address this crisis and not make the victims of armed conflict suffer even more from the situation. And it is incumbent, therefore, upon all the parties to these armed conflicts, including non-state actors, to accept fire. And he's been putting a lot into that campaign, which so far has the various institutions, the high-level political forums, and so on, that are trying to address how we move ahead, are with respect to each one of them examining the consequences of the pandemic. And it would take us another 5 or 6 hours to go through what each expert group, interagency expert panel is addressing, looking at the specific, obviously, the health-related SDGs are important ones. The world is going to be set back considerably. So the question has been put out there. Do you acknowledge the fact that the goals, and I don't know if there's been a definitive answer to that, but the question has been posed, that one of the values of the 2030 Development Agenda, adopted in September 2015, and that has gained tremendous support and solidarity, and has appeared by most specialists to be fairly realistic in identifying attainable targets and indicators to reach those targets, has now been upset. And we don't know whether or not it is at all realistic to try to adjust those targets. And that is a major challenge facing the Sustainable Development Goal agenda.
Thank you very much, Steve, for that. We are, of course, coming close to the end of this program, while there are another 75 questions that are unanswered. Pinky, as part of the closing remarks, if you can talk to the students of law who are attending this program. There are lots of them who are attending this program. They are looking at this crisis. They feel anxious about the future. They feel anxious about their legal careers. How do you want to tell them? What do you want to tell them about how this crisis might potentially impact, and what is your message for the students of law out there who are watching this program?
Raj, I think what I would say to all the students and to all of us here is, there is always something good that happens even during a crisis. In fact, we sometimes learn the best. And I think we ought to utilize this kind of time. The first feature utilize the time that we have at present to develop our skill sets, to actually step back in time, to re-evaluate and literally reinvent ourselves. So to that extent, I'm afraid that the students who have grown to a certain belief would need to reorient themselves to some extent. I think the world is here to stay, and I think we will evolve ourselves out of this. But while we are here, we are learning so much about access to justice. We are learning the true meaning of justice. We are learning to discuss and to bring forth issues that need to be addressed. So maybe some of these, I would urge the students to look at some of the issues that are arising today and are likely to arise in future. For example, as you mentioned, force majeure as a commercial issue, and of course the other questions relating to constitutionality and various other issues connected thereto. I don't think that the world will keep the legal services on the side. It is an integral part of our system. In fact, Rahul, you flagged it well by calling it, by saying it might be need to be addressed as an essential service. In US, of course, lawyers are considered part of essential service, and willy-nilly they are functioning in that capacity. I think we are slowly but steadily moving back to an horizon whereby we will be working, of course, in fits and starts to get to the ultimate, but we are moving at 100%. There is nothing in the world to be unhopeful about. I think we have the best to look forward to and the best to rise ourselves out of this.
Thank you so much, Pinky, for those really optimistic and hopeful remarks. Rahul, would you, besides answering that question, would you also answer the question which I'm always concerned about, in the sense that to what extent this crisis, gives us lessons for the young people and the future generation of lawyers to be conscious about rights and justice even during these times?
Surely. Raj, first question, I think for the young people, I don't think you need to lose heart. I think it's a great opportunity, like Pinky ji has just mentioned, that just step back, reflect, introspect. There's so much of time at hand on hand that you can almost do everything that you wanted, and for everything that you always had an excuse, now there is no excuse. So please go ahead and do it. Follow your passions. Life is not all about work. Work and play need to go together. You will definitely come back to the real world, but right now it's time to spend time with your grandparents. Play, if you're married, play with your children. Spend quality time at home with everybody who needs you around, who probably was missing you for all these years. Just taking a leap out of what I do. Thankfully, just a night before the lockdown, I called for a table tennis table to my residence, and we play almost an hour or a couple of hours of table tennis every day. If time permits, one can do that much. But otherwise, at least we try before meals, after meals, in between to squeeze time. Play certain board games with children. So just spend time. Forget about life. Life is this. Unfortunately, we thought life is all about earning big bucks, running after something. The whole purpose of life is to have a happy home, and right now that's the time which God has given you. So spend time. We are privileged. Please, think about practicing gratitude. So much God has given us. We can actually have social distancing, which is a casualty for majority of Indians. So contribute with the NGOs if you can, without putting yourself at risk. Follow your passion. Be healthy. Eat good. Think good. Do good if you can. Use your voice for certain issues, social issues, human rights issues, various other issues. Help the individual next door. Start. Charity always begins at home. Have elated and enlightened, full of very vociferous and these kind of engaging conversations at the family dining tables. Engage with friends. Have these Zoom conversations. So there's so much you can do. And let me tell you, at the end of the day, the entire world has missed 2020. So it's not only you who is one year back. We all are 1 year back. So we all start at the same place when the world opens up. So it's not doomsday. Be an optimist, live life to the fullest. This is the time.
Thank you so much, Rahul, for those really inspiring words of wisdom for our viewers, particularly a lot of young people. Geeta, that's you. Over to you.
So all I can say is that change is the only constant. And however, feel a little sorry when I get all these internship applications and I have to turn them down or defer them because we won't be able to teach them anything at this point. We ourselves are not that, for a young person who's applying for internships, looking at his peers, looking at his colleagues, and saying, so and so had 10 internships, I have none. You are fortunate, you're among the fortunate few who can have online lessons, who can attend webinars. Please enjoy yourself. Just enjoy this period.
Thank you so much, Geeta. I appreciate the fact that you reminded a lot of our young people that they are indeed privileged and they should use that privilege for learning new things and being appreciative of that moment.
Well, Professor, I would say there's a lot of great legal literature coming out right now. The opportunities for law students are unrivaled. I mean, they didn't exist 5 years or 10 years ago. This is a great time, as my peers on this panel said, to reacquaint oneself with these pleasures. And I think reading is always a great companion in times like this. And can direct them to fantastic books that are coming out right now, fantastic works that are coming out right now. All the major publications of the world have made their COVID coverage free of cost. So you can read all the opinion editorials, get all the information that you need. And of course, I think at a young age, it's important to develop the ability to ask questions and to think critically. I think that's a very vital part of any education. So I think this is the time to start asking questions. I think that's a fundamental feature in a legal education. So that's it, I guess.
Thank you so much, Mohammed. Steve, over to you.
Thank you. And this is an opportunity to speak to budding law students. As I understand it, what are the takeaways from this event? The title is Protecting Civil Liberties During Emergencies. Does COVID-19 pose new threats for rights and freedoms? That does raise a deeper question: what is the role of law? Is law an institution that you are training for that exists to protect and expand the wealth of those who have wealth? Or is law at the same time, because you can't deny that that is an accurate depiction of what lawyers do, they protect the interests of their clients, who tend to have resources that you want to protect and expand. Times of emergency are not just this crisis, but the emergency that we will return to, which is the climate emergency. What you need to address as young people is not the world that we older people are trying to preserve and maintain and balance law as a tool of justice and law as a tool of preserving wealth, but on the contrary, having a much broader image of how we're going to preserve this planet and civilization, because they are at stake. We are in an emergency situation. Once this is over, this is one pandemic among many pandemics. There are many other manifestations of the climate crisis that you will need to address, and use the legal profession to do so wisely. Good luck.
Thank you very much, Steve. And with that, we come to the end of this fascinating colloquium. I cannot thank enough of my wonderful guests. I was, of course, very conscious of the fact that I have 3 distinguished lawyers representing 3 different political parties, but we couldn't have had a better experience of having them. We have another, of course, distinguished lawyer here. All of you were absolutely amazing. Thank you, Steve, for being here. I think one of the things those who watch this program will know that you can have a very reasoned and a very composed debate on extremely difficult and complex issues where reasonable people can disagree. And one of the things that all of you quite remarkably demonstrated is your commitment to truth and justice, but most importantly, civility in civic discourse. I'm grateful to you for your time, most importantly for your leadership and the extraordinary contributions that each one of you are making in your own life with the view to protecting rights freedoms, and indeed civil liberties. With that, I would like to sign off, and I would like to also appreciate the fact that our viewers have joined. Over 1,450 people registered, and we're very grateful for them to join this public interest initiative of OP Jindal Global University and Jindal Global Law School. I would like to remind you that on Saturday, 16th, we will have the next program, Global Legal Practitioners Colloquium, on the theme, the future of litigation and court practice in India and United States. I have another wonderful group of guests. We have Honorable Mr. Justice Matthew Cooper, Judge of the Supreme Court of New York, Ms. Devika Keval Ramani, partner and chair of the international law firm Moses and Singer, Honorable Ms. Justice Geeta Mittal, Chief Justice of the Jammu and Kashmir High Court, and Dr. Abhishek Manu Singhvi, Senior Advocate, Supreme Court of India. They will join me at the same time on Saturday, 16th at 6:30 p.m. To have this discussion. I would like to extend a warm welcome to all of you to join that. With those words, thank you very much.
Thank you. Thank you.
Thank you.
It's an honor to be here.
Thank you so much, Raj. Thanks a lot.
Thank you.